Hello and welcome back to another video on my channel. Today we're going to be taking a look at the origins or the foundation for what has grown into this court's desire to review the president's power to fire and mainly this unitary executive theory. Why this comes up is there's a case coming up, another one on the docket. We talked about Slaughter versus Trump and how the oral arguments went for that, but there's another similar case coming up, and this is the Cook versus Trump case. It's one of several that challenge the key protection that gives several administrative agencies independence from the president's control. And so I want to get into what this unitary executive theory is before we get into its origins and what sort of laid the groundwork for this court to take these on and articulate its opinions, assuming it is going to expand the president's power to fire. So Article 2 of the United States Constitution provides that the executive power shall be vested in a President of the United States of America. This statement gave rise to a theory of U.S. constitutional law that posits the president should have control over the entire executive branch. This theory has been given increasing attention with the rise of the administrative state. Some argue the president does not have enough direct power over executive branch agencies, and that this is a violation of the clear statement in Article 2, Section 1 of the Constitution. Others argue that allowing the presidency more power would lead to a more dictatorial executive branch and lead to a weakening of democracy. All right, so again, I'm not here to tell you what to think. I am here simply to provide you information to consider when you're thinking about this for yourself and arriving, hopefully, at your own conclusions. So let's move to what I believe are sort of the origins of this, and that is going to be one of the most famous dissents perhaps of all time, but definitely of Scalia's works. This is going to come up on any list of Scalia's best or most important opinions, and that's going to be Morrison versus Olson. A little bit of a background to Morrison versus Olson. This court was essentially deciding a core constitutional question: can Congress create a prosecutor who exercises executive power but is largely insulated from the presidential control? More bluntly, how much executive power can Congress take away from the president without violating separation of powers? The majority's holding that Scalia ultimately rejects is this idea that the independent counsel does not interfere too much with the president's exercise of executive power. The president still had some control via the attorney general's power to remove for good cause, and therefore it is constitutional. And they're going to reject that formalistic view that Scalia is going to advocate for, that all executive power, 100%, must be fully controlled by the president. So let's go ahead with that in mind, get into the opinion. And again, one of these lines to me sticks out because it is almost exactly what Brett Kavanaugh was asking about in oral arguments in the Trump v. Slaughter case. And we'll get to that in a minute. So Scalia opens it up with talking about the Constitution, but most importantly, this case being about separation of powers. He notes that the framers of the federal Constitution viewed the principle of separation of powers as the absolutely central guarantee of a just government. So to him, a lot is at stake in this case. And again, he is the lone dissent in this. This is a 1 versus 8. And it's interesting enough that a lot of scholars today, maybe the majority, agree that Scalia was actually right about this case. His dissent has become more popular in time, and more people have sided with him. Interestingly enough, and I will caveat that by saying, amongst those scholars who believe Scalia was right to dissent, there's a disagreement about what he was right about. Some would say, on one end of the spectrum, they would say he was right about the way that this statute would ultimately be used. But the other end of it is to say he would be right about the core idea that the executive should be 100% in charge of the executive branch, and there should be none of this investigative committee business with prosecutorial power. Here, Scalia is going to point out, again, what the Constitution says that we already noted in the previous tab, but he's going to say that to him, this does not mean some of the executive power, but all of the executive power. The test that Scalia is going to offer here is, first, is the conduct of a criminal prosecution the exercise of a purely executive power? To him, the answer is obviously yes. Does the statute deprive the President of the United States of exclusive control over the exercise of that power? Surprisingly, to say, the court appears to concede an affirmative answer to both questions, but seeks to avoid the inevitable conclusion. And so here, this is where Scalia sees just a blatant contradiction of what we are doing and what the Constitution stands for and how it is being rejected ultimately. Now, here Scalia is also going to identify the roots or the origins of this as coming with Humphrey's executor. Humphrey's executor was about limiting removal power to good cause, and it was an impediment to an effective grant of presidential control. We said that limitation was necessary with respect to members of the FTC. What we, in Humphrey's executor, found to be a means of eliminating presidential control, the court today considers the most important means of assuring presidential control. Congress, of course, operated under no such illusion when it enacted this statute, describing the good cause limitation as protecting the independent counsel's ability to act independently of the president's direct control, since it permits removal only for misconduct. The next thing I find noteworthy here is how Scalia points out again, that it is about 100% of the executive's ability to control the executive. As I have said, however, it is ultimately irrelevant how much the statute reduces presidential control. The case is over when the court acknowledges, as it must, that it is undeniable that the act reduces the amount of control or supervision that the Attorney General, and through him the President, exercises over the investigation and prosecution of a certain class of alleged criminal activity. It affects a revolution in our constitutional jurisprudence for the court. So here, this is what is at stake for Scalia, and this is the same case where he says this wolf comes as a wolf. This is a huge threat to our Constitution and our separation of powers as we know it. And ultimately, because of these principles of separation of powers, Scalia is going to conclude it is not for us to determine how much of the purely executive powers of the government must be within the full control of the president. The Constitution prescribes that they all are 100%. Now, again, a lot of people, when hearing that the president gets 100% of the executive powers, prosecutorial powers, begs the question of, well, okay, who gets to investigate the president then? Who gets to investigate his administration when things go awry? And here Scalia points out the following. Is it unthinkable that the president should have such exclusive power, even when alleged crimes by him or his close associates are at issue? No more so than that Congress should have the exclusive power of legislation, even when what is at issue is its own exemption from the burdens of certain laws. And here he gives an example of that. No more so than this court should have the exclusive power to pronounce the final decision on justiciable cases and controversies, even those pertaining to the constitutionality of a statute reducing the salaries of the justices. So there, we see that in this separation of powers, there will always come an issue where a branch of government can use the separation of powers, its powers it was given, to its own advantage in a way that we might find unethical or distasteful. But ultimately, this should not trump or overcome what the founders envisioned, because the separation of powers is more important than those concerns in Scalia's position. Okay, the other thing that I thought was really interesting about the dissent, and something that you might have an opinion on for yourself, looking back on recent history, is whether or not this has panned out true or not. But even in Scalia's time, he already perceived it as having been true. He says, besides weakening the presidency by reducing the zeal of his staff, it must also be obvious that the institution of the independent counsel enfeebles him more directly in his constant confrontations with Congress. By eroding his public support, nothing is so politically as effective as the ability to charge that one's opponent and his associates are not merely wrong-headed, naive, and effective, but in all probability, quote, crooks, and nothing so effectively gives an appearance of validity to such charges as a Justice Department investigation, and even better, prosecution. The present statute provides ample means for that sort of attack, assuring that massive and lengthy investigations will occur, not merely when the Justice Department, in the application of its usual standards, believes they are called for, but whenever it cannot be said that there are no reasonable grounds to believe they are called for. The statute's highly visible procedure assure, moreover, that unlike most investigations, these will be widely known and prominently displayed. And here he points out his reason for saying this. Thus, in the 10 years since the institution of the independent counsel was established by law, there have been 9 highly publicized investigations, a source of constant political damage to 2 different administrations. So that is Scalia's issue here, the political ramifications and how this is giving more power to Congress. So he says, in sum, the statute does deprive the president of substantial control over the prosecutory functions performed by the independent counsel, and it does substantially affect the balance of powers. And he points out the folly of the new system of standardless judicial allocation of powers we adopt today, where the court will determine when something goes too far and takes away too much of the executive's power. I also want to point out another reason why I believe this dissent gains more and more traction over time is this increasing idea of the administrative state. And here I will point out Scalia seems to foreshadow this. Since our 1935 decision in Humphrey's Executor, which was considered by many at the time the product of an activist, anti-New Deal court bent on reducing the power of President FDR, it has been established that the line of permissible restriction upon removal of principal officers lies at the point at which the power exercised by those officers are no longer purely executive. Thus, removal restrictions have been generally regarded as lawful for so-called independent regulatory agencies. Now, this phrase, independent regulatory agencies, is going to evolve into what is now referred to as the administrative state. But Scalia posits that this case goes even further and is even worse than Humphrey's Executor. Here he says what Humphrey's Executor and presumable Myers really means, we are now told, is not that there are any rigid categories of those officials who may or may not be removed at will by president, because again, Humphrey's Executor was about classifying them as quasi this, quasi that, or purely executive. He says, no longer do we have the rigid categories to determine our answer, but simply that Congress cannot interfere with the president's exercise of the executive power and his constitutional constitutionally appointed duty to take care that the laws be faithfully executed. So now they can go even further so long as the court can say, well, it's not impeding on his abilities. In his opinion, there are now no lines. If the removal of a prosecutor, the virtual embodiment of the power to take care that the laws be faithfully executed, can be restricted, what officer's removal cannot? This is an open invitation for Congress to experiment. Now, you can go and listen to the oral arguments of Slaughter versus Trump, and in that case, you'll see Brett Kavanaugh ask very directly the question that what are the limits to exactly this situation? Can Congress start creating its own positions that effectively replace cabinet members or things like that? What are the limits? And there wasn't really a good answer given for that. So I do think this court is going to change something here soon. The court essentially says to the president, trust us, we will make sure that you are able to accomplish your constitutional role. I think the Constitution gives the president and the people more protection than that. Ultimately, to conclude and wrap up, these are the foundations, this is the groundwork for what I believe is going to be a lot of the language, the ideas, the articulation of this court's impending reversal of a lot of these previous understandings of the executive power, separation of powers, and the start of a return to previous, prior to Morrison versus Olson levels of executive power, or going even further to prior to FDR, Humphrey's executor levels of executive power. So I hope you found this informative, helpful, insightful. Let me know pros and cons, your opinions in the comments below, and have a good rest of your day.